Good morning, everyone, and thank you for joining us for this live web stream, both the people in the room at the Law Society here in Wellington and you at your computer, for this New Zealand Law Society CLE live web stream webinar on the AML CFT Act, sponsored by the Department of Internal Affairs. I'm Sarah Loftus from CLE, and I'm your host today. Our presenter today is Kate Reid, welcome, from the Department of Internal Affairs, and I'll hand over to her in a moment. The presentation is an hour and a half long, including time at the end for questions, and you can ask questions by writing them in the box at the bottom of your screen. All the questions will be gathered by our staff here, and Kate has set aside time at the end of her presentation to answer some of them. Obviously, she won't have time to answer all of them. But there will be some written answers prepared after, in the next week or two to the most frequent questions, and those answers will be distributed to you by email in the next week or two. So please ask your question, that is, write it in the box on the screen during the presentation rather than towards the end during the question time, because if you keep it to the end, obviously there's really no way it might be answered. So thank you, Kate. It's all yours.
Thanks. Good morning, and can I just extend a welcome to all of you to the growing partnership of people, businesses, government agencies who are involved in anti-money laundering in New Zealand, and also thank you for taking the time to listen to this talk. As Sarah said, I am Kate Reid. I'm the Director of the Phase 2 Implementation Program for the Anti-Money Laundering, Countering Financing Terrorism Act. Also, I'd like to thank the Law Society for making the space and time available for this webcast. I'm having problems with the clicker already. There we go. What I want to cover in this presentation, I'll be looking generally at what AML CFT is, why do we have it, some detail on the money laundering and terrorism financing risks that you may encounter in your business, an outline of the legislative amendments under Phase 2, how they affect you and your obligations under the Act, your regulatory obligations, key upcoming dates in the rollout of Phase 2, and a little bit about the Department of Internal Affairs, our approach to regulation, and what you can expect from us as your AML CFT supervisor. It's a complex subject, and I'm not going to be able to cover everything in the space of just over an hour, but there'll be further opportunities for you to get information from us. We have a number of pieces of guidance which I will be referring to repeatedly through this talk, and they will all be out by Christmas. We've got roadshows planned for lawyers and conveyancers. Those are going to take place in approximately February or March. They're still in the planning stage, but just look out for the times of a roadshow near you. And also there's the ongoing possibility of having further webcasts and webinars through the Law Society, so look out for those as well. I'll probably have time to answer a few questions at the end, but the remaining questions are being recorded and we'll compile them and email responses to all attendees. A word on jargon. Like all specialised fields, AML CFT has its own vocabulary. So I'll try and explain things in simple terms, but please bear with me if I occasionally lapse into the jargon. You're probably going to need to get used to some of these terms anyway. A particular difference about lawyers, I know, is that what the Act refers to as a customer is what you refer to as a client. So just when I say customer, read client. All right. Okay, so what is money laundering and terrorism financing? Money laundering is the process that criminals use to clean the money they make from crimes. By making the money look like it comes from a legitimate source, they can cover their tracks and avoid detection. And they do this by buying, selling and channeling funds through things such as property, expensive goods and financial services. They move it around as much as they can to disguise the criminal origins of those funds. And they then spend the money or use it to fund further criminal activities. Money laundering makes it harder for authorities to find out where that dirty money comes from, to stop crime, prosecute criminals and seize illegally earned money and assets. Money laundering isn't just a suitcase full of used $20 bills smelling of marijuana. Increasingly, money is laundered electronically and across borders. People who finance terrorism use similar methods to money launderers to channel funds to violent causes and to disguise who is providing and receiving the money. A question I'm often asked is, does this stuff really happen in New Zealand? Isn't this all big organised crime? Well, actually, any crime that generates a significant amount of money, you're going to have to launder it. So money laundering is actually happening every day across New Zealand. The Police Financial Intelligence Unit estimate that it's about $1.35 billion from fraud and illegal drugs alone, laundered through legitimate businesses in New Zealand every year. However, the true cost and impact is many times that figure when you factor in all the crimes that generate dirty money and the human toll those crimes take on victims and on the wider community. International criminals also try to take advantage of our clean reputation to launder funds through New Zealand businesses, so that brings in crimes like human trafficking, tax evasion and corruption from overseas. New Zealand is also exposed to threats relating to the financing of terrorism, including the potential for finances of overseas groups within New Zealand and overseas-based groups who may seek to use New Zealand as a channel for funds. While the frequency of terrorism financing is low, the potential consequences are significant, so it's important for businesses to watch for red flags that may indicate terrorism financing activity. Now this is where you get a little bit of a sneak preview of our Phase 2 sector risk assessment, which will be released towards the end of this year. How is New Zealand vulnerable to money laundering and terrorism financing, and what are the main kind of methods that are used to conduct money laundering in New Zealand? One of the main vulnerabilities is and remains cash. So crimes such as drug dealing and converting stolen property generally generates proceeds in cash. Cash remains popular for money laundering because it's anonymous, doesn't require any record keeping, and it can be used to move or store value outside formal financial institutions. New payment technologies are kind of almost the other end of the scale, and they can increase the opportunities for money laundering and terrorism financing, in particular where they allow criminals to exploit developments that break down the barriers posed by international borders. Technology that can be accessed remotely anywhere in the world, that can move funds quickly, and that allows the quick reintegration of the proceeds of crime back into the financial system will be attractive to launderers and terrorist financiers. New payment technologies may increase anonymity, for example, by allowing more person-to-person transactions outside the regulated financial sector, placing a layer between individuals undertaking transactions and reporting entities. Real estate is another vulnerable area. The Financial Intelligence Unit has identified hiding the ownership of property as a common money laundering method, often by placing the property in the name of a trust set up by a lawyer. Another common method identified by the FIU was transferring the criminal proceeds to a lawyer or real estate agent by electronic transfer. In 2007, a Financial Action Task Force typology study on real estate identified a number of areas of opportunity for money launderers, including the use of gatekeeper professionals to access financial services, facilitate transactions through client trust accounts, or to act as intermediaries in transactions. The use of corporate vehicles, such as offshore companies, trusts, shell companies, and property management companies, and the use of mortgages, such as funding mortgages with proceeds of crime. Anonymity. Any products, services, business relationships, or methods of delivery that facilitate anonymity or the disguising of identity or ownership represent a high money laundering and terrorism financing risk. The broad range of professional services offered by gatekeepers, such as lawyers, enable money launderers to manage all their financial and business affairs in one place. Professionals can act on behalf of clients in respect of both financial and legal affairs. They can be used unwittingly to facilitate a range of illicit transfers. Typically, a money launderer arranges for the professional to set up a company or trust, and then also act or arrange for a third party to act in a proxy role, including acting as a trustee, nominee resident director, or nominee shareholder. With the fiduciary role appearing legitimate, the money launderer can conduct a range of criminal activity or asset transfers at arm's length from both the regulatory and law enforcement agencies. And finally, lack of awareness. While many reporting entities consider themselves as at low risk of money laundering activity, their lack of awareness of the topic may make them more vulnerable to abuse by money launderers and terrorist financiers. Establishing and maintaining an AML CFT culture from the top down in the firm is an important part of having an effective regime. And a few high-risk factors. So these are frequent vehicles for the use of money laundering. Trusts and shell companies. New Zealand company structures and trusts are attractive to money launderers because New Zealand's reputation as a well-regulated jurisdiction provides a veneer of legitimacy and credibility. It's easy and inexpensive to register companies and set up trusts in New Zealand, and they're essentially disposable and cheap to replace. Trusts and other legal entities may be used to create complex legal structures that obscure beneficial ownership and the involvement of the natural persons connected to the predicate offending. Using shell companies to conduct transactions and activities helps criminals hide the beneficial ownership or effective control of the company behind nominee directors. International payments through the mainstream financial sector appear to be the primary means for money launderers and terrorist financiers to move illicit funds offshore. The use of wire transfers to move funds cross-border relatively quickly is recognised internationally as one of the most common methods to launder funds. Client accounts or trust accounts may be an attractive option for criminals to place funds, particularly if the criminal perceives that the respectability and legitimacy added by using a professional service, is likely to result in less CDD than approaching a financial institution such as a bank. The use of clients' accounts is attractive to criminals as client accounts can be used as part of the first step in converting proceeds of crime into other less suspicious assets. They can also permit access to the financial system when the criminal may otherwise appear suspicious or undesirable to a financial institution. They can serve to hide the true ownership of criminally derived funds or other assets, and they can be used as a link between different money laundering techniques, such as purchasing real estate and setting up a shell company. High-risk customers and jurisdictions. There are certain occupations or businesses that are considered high risk depending on their exposure to other money laundering or terrorism financing vulnerabilities. For example, customers who are involved in high-value or cash-intensive businesses, money service businesses, alternative remitters outside of the formal financial sector. There's no universally agreed definition of a high-risk country, but high-risk countries may include those identified as lacking adequate AML or CFT systems, measures or controls, harbouring supporters of terrorism or the financing of terrorism, having significant levels of corruption or organised crime, or being subject to sanctions, embargoes or other similar measures. Politically exposed persons and high net worth individuals. Reporting entities should establish whether the customer is a politically exposed person, a PEP. That is, a person in a position of power in their home country, so a politician, high court judge, people who are high in the military, or a relative or close associate of a PEP. Foreign PEPs may use banking facilities in other countries to launder funds away from scrutiny in their home jurisdiction using the New Zealand financial system. The position of power of PEPs and the control they may exert in their home country means that it may be easier for them to access the proceeds of crime. Such funds may be diverted from legitimate sources, or they may be the result of corruption or bribery. Facilities provided to higher net worth customers and heads of international organisations can be misused for money laundering. This is especially the case if transactions are rarely questioned because of the high value of the business to the reporting entity. PEPs and high net worth individuals who come from countries or regions where corruption is endemic, organised and systemic present the greatest risk. However, it should be noted that corrupt or dishonest PEPs and high net worth individuals can be found in almost any country. So drilling down now to the legal sector and the risk identified there. Again, this is from our Phase 2 sector risk assessment. So we have assessed the risk of money laundering or terrorism financing occurring within the legal sector as medium to high. So that's the inherent risk if you don't have any money laundering controls. So without AML controls, the legal sector lends itself to a higher inherent risk of money laundering because client relationships can be complex and the identity of beneficial owners may not be clear. The ease of access to the legal sector, its wide geographic spread, the gatekeeper role it plays in accessing the financial sector, and the veneer of respectability it affords all compound money laundering and terrorism financing risk. Lawyers offer numerous products and services that can be used to facilitate money laundering, including setting up and managing trusts, companies, and other legal arrangements. Many of these products and services are internationally recognised as presenting a high risk of money laundering and terrorism financing. This diagram was published by the Financial Action Task Force in a publication from 2013 about vulnerabilities of legal professionals. What it shows are two trajectories of involvement in a suspicious activity or transaction, ranging from innocent involvement through to being an unwitting dupe, and then through to identifying a red flag, so a potentially suspicious thing that you note about an activity or transaction that one of your clients is engaged in. At that point, it sort of bifurcates into the high road and the low road. The high road is where you are alert and proactive, you have appropriate money laundering controls and processes in your firm, you report the suspicious activity, and then you take appropriate action, which may include closing off your relationship with your client. The low road goes through from being willfully blind to those red flags through to becoming corrupted and actually complicit in the laundering itself. Now, obviously, that's not the road that you want to follow. So what we're trying to do with regulating money laundering and terrorism financing is two things. One is we're trying to ensure that people know how to get onto that high road, how to actually record, look out for red flags and record and report suspicious transactions. And also we're trying to push that red flag box back a bit towards the left so that there's less chance of you being unwittingly involved in money laundering activity because you'll be actually looking out for things that may be suspicious. So I've talked about money laundering and terrorism financing. So what's the opposite? What's anti-money laundering? Essentially, the point of the anti-money laundering regime is to enlist businesses and professionals in a partnership with government. And it does that by getting businesses and professionals to put in place systems and processes that deter criminals from trying to exploit them to launder the proceeds of their crime, and also to report suspicious transactions and activities. Regulated businesses are referred to as reporting entities, so that's a nice bit of jargon for you. If I talk about a reporting entity at any stage during this talk, you know I'm talking about your firm. Effective AML CFT measures help to stop criminals laundering the proceeds of fraud, drugs, tax evasion and other crimes through legitimate New Zealand businesses. They also make it easier for authorities to trace the proceeds of crime and easier for police to prosecute offenders and seize illegally earned money and assets. The regime introduced under the Act enables AML CFT activities to be based on risk. Risk is assessed at three levels. There's a national risk assessment of money laundering and terrorism financing threats and vulnerabilities, and that's done by the Police Financial Intelligence Unit. Each AML CFT supervisory agency undertakes sector risk assessments in respect to their regulated sectors. And finally, there are individual risk assessments undertaken by each reporting entity or regulated business. The purpose of this risk-based approach is to make sure that AML CFT measures are proportionate and resources are targeted mainly towards the high-risk and high-priority areas. It's important to understand that in a risk-based approach regime, not all entities will adopt the same AML CFT controls. Context is everything in regard to the risk-based approach, and no two reporting entities are the same. A risk-based approach recognises that there can never be a zero-risk situation and allows reporting entities to determine the level of money laundering or terrorism financing exposure they can tolerate. A high-risk situation is not necessarily a situation you will avoid. You may choose to avoid it, for example, by disallowing certain types of service or client, or you might decide to allow risky situations, but take appropriate steps to mitigate and manage them. So Phase 2 brings in amendments to the Basic Act, the Anti-Money Laundering and Countering Financing of Terrorism Act 2009. The new laws extend the current AML CFT Act to cover more businesses. So under the new legislation, we're the supervisor for all so-called Phase 2 sectors: lawyers, accountants, real estate agents, conveyancers, high-value goods dealers, and the New Zealand Racing Board. There are an estimated 6,000 businesses in these new sectors. That compares to about 10,000 of businesses, mainly in the financial sector that we currently supervise. So the 1,000 business we currently supervise across a number of sectors, including money remitters, lenders, casinos, and trust and company service providers. And the Act also makes some changes that affect those businesses that are currently captured by the Act. This is a fairly self-explanatory slide, just showing the phased introduction. So lawyers and conveyancers are the first cab off the rank on the 1st of July, followed by accountants in October, real estate agents in January 2019, and high-value dealers in the Racing Board, bringing up the rear. Okay, so what's the purpose of bringing these new sectors into the regime? I think it's fair to say that it was always the government's intention that non-financial businesses would be included, but issues such as the Panama Papers brought an increased focus on the role of corporate and trust structures in money laundering, and that accelerated the policy process. As I've already noted, services provided by professionals, including lawyers, are vulnerable to money laundering and terrorism financing. Introducing AML CFT measures will deter criminals from using your services and help detect them if they do. Importantly, it will also strengthen the overall AML CFT system. For example, a lawyer may detect red flags that may not be picked up by banks or other financial service providers who interact with the same clients. You may have more information about the people or funds involved in a particular transaction or activity than a bank does, because you're looking at the same transaction from a different angle. This may seem like double handling, but is incredibly valuable to the law enforcement authorities when they're investigating crime. Compliance also has a value for business risk management. As a professional, you closely guard your reputation. It's in your interest to avoid relationship with customers who will cause you disrepute in the legal community or censure by your professional body or government authorities. Businesses that fail to comply and are misused by criminals risk negative media coverage both in New Zealand and internationally. Finally, Phase 2 brings New Zealand into line with international standards and strengthens our reputation as a safe place to do business. AML CFT is now standard good business practice around the world. So this is a list of the activities that are covered. The AML CFT Act is activities-based. This is not the exact wording of the Act, it's what I could fit on the slide, basically. But it summarises how the professions are being brought into the legislation. Activities that don't fall into one of these categories, which I'll let you read by yourselves, are not captured by the Act, and the compliance requirements don't apply to those particular activities. Lawyers and conveyancers need to develop a thorough understanding of the nature of each of these captured activities and what obligations are related to the captured activities. Further information on this will be provided in the Lawyers and Conveyancers Guidance, which is out later this year. Whether an activity is in your ordinary course of business will always be a matter of judgment depending on the nature of your business. Some relevant factors to take into consideration would be whether the activity is predictable, consistent, regular, frequent, whether it involves significant amounts of money, is a source of income, or involves significant resources for your business. It's likely that the activity is in the ordinary course of your business if one or more of these factors apply. And updated guidance on that will also be released in December. Okay, moving on to your obligations under the Act. So the first steps for a law firm in setting up an AML CFT function to appoint a compliance officer, undertake a risk assessment of the money laundering and terrorism financing risks in your business, informed by the sector risk assessment, which we intend to publish before Christmas. Build your AML CFT program to mitigate those risks. And I should say that the initial setup is actually the hardest part. Once your program is up and running, it will eventually become second nature and just another part of your business. But you do need to get started now. The compliance officer should be an employee of the business who reports to a senior manager or partner of the business. If practicing on their own account, a lawyer would be expected to act as the compliance officer themselves and take full responsibility for all compliance requirements unless there is a reason why they cannot. In that case, they should appoint a third party to take on this duty. The right person is someone who's suitably qualified and trained with a direct line to senior management, and importantly, the ability to influence senior management and possibly argue with them if there's a situation of non-compliance or if things need to be changed. It's good to have someone for that reason who isn't shy, so that they can engage proactively with senior management and also with the Department of Internal Affairs as their AML CFT supervisor. It's good to have someone who's committed to the position as it's a serious role with serious obligations. It will help if they've got previous knowledge of AML CFT, but a willingness and ability to learn is the key. When you've appointed your compliance officer, or if your compliance officer or other contact information changes, it's important that you advise us at DIA. This enables us to communicate effectively with you and provide you with important information and updates. For your risk assessment, you need to assess the business and identify the money laundering and financing of terrorism risks that may be faced in the ordinary course of your business. Use what you know. You know your business, you know the products and services you offer, who you deal with, and the types of customers you have. Among other things, your risk assessment should consider the nature, size, and complexity of your business. In general, complex and large businesses are probably more risky, although small businesses may be targeted because they are perceived as soft touches, so therefore they might be vulnerable too. You need to look at the products and services that you provide. Are they identified as vulnerable in the sector risk assessment? You need to look at the method of delivery. So, for example, do you deliver your services mainly online, or do you tend to have face-to-face relationships with your customers? The types of clients you have. So do you have a lot of offshore clients, or are your clients mostly local? Do you deal mainly with companies, or do you deal with individuals? The countries you deal with, are they identified as high-risk jurisdictions? For example, are they on international watch lists? Your risk assessment should be based on your practical, hands-on experience. Tailor the specific risks to what you expect to see in your business. Pretend you're writing it for someone who doesn't know anything about your business. Include what you know. The more you put in, the better. A new staff member should be able to pick it up and understand the context of your products, your customers, and what risks you face. You should, indeed you're required to, use guidance including the sector risk assessment when it's published, but you don't have to wait. There are currently international resources about money laundering risks in the context of the legal sector. For example, helpful resources are published by the Financial Action Task Force and the International Bar Association. Also, make use of the existing guidance on the DIA website. Now, that guidance has got a financial sector flavour and it needs updating, but it can still give you valuable advice on doing your risk assessment and setting up your AML CFT program. Risk assessments are required to be regularly reviewed and updated. Good triggers for when to do that are when there's any material change to the business, its service offerings, or its customer base, or where deficiencies in the effectiveness of the risk assessment are identified. Your AML CFT program is your compliance manual. Once you know what your risks are, how are you going to mitigate those risks? It's not just parroting or repeating the requirements of the Act. It includes policies, procedures, and internal controls. And it needs to be tailored to your business, not only to the specific risks identified in your business, but things like your staff structure and accountabilities, and the specific internal control systems that you have. In other words, it needs to identify not only what you do to comply with the Act, but how you do it. For example, it should include not only a statement that you're going to regularly review your risk assessment and program, but how often and how that review will be undertaken, what triggers it and who is responsible for it. Your AML CFT program should be something, again, that a new staff member could pick up, read and understand what they need to do in their job so that the company is meeting or exceeding its AML CFT obligations. For both your risk assessment and your AML CFT program, start thinking about it early. We recognise it's a challenge, but start now. Don't leave it to the last minute, that will just make it harder. And leave room to get advice from us or from the Law Society if you need to. So these are some of the elements that you need to include in your AML CFT program. Procedures for carrying out all these ongoing requirements need to be in the program. Customer due diligence, which is identifying and verifying the identity of customers and obtaining other essential information before providing any service that's covered by the AML CFT Act. Submitting a prescribed transaction report to the police, or Financial Intelligence Unit for large cash transactions. I'll talk a little bit more about that in a minute. Monitoring customers' accounts to identify potential warning signs of money laundering and terrorism financing, and reporting any suspicious transactions or activity to the Financial Intelligence Unit. Vetting senior managers, the AML CFT compliance officer and other staff who have AML CFT related duties, training staff as required, and regularly reviewing your risk assessment and compliance program. AML CFT compliance cannot be achieved with a set and forget approach. The AML CFT program needs to be fully implemented within the business. It should be a living and adaptable program. You need to have your risk assessment and compliance program audited regularly, and you need to submit an annual report to the Department of Internal Affairs. Okay, I'll go into a bit more detail on some of those things. Customer due diligence, although I have to say that this section is a once over lightly. Customer due diligence is something that I can't really do justice to in the time I've got available today. If you need further information, then I really recommend that you have a look at our guidance, both what's online at the moment and the lawyers and conveyancers guidance once it comes out. So there are 3 levels of CDD. You need to be sure you use the right level, which will depend on the characteristics of the customer, the nature of the activities and transactions that you're facilitating, and the potential for risk. So the 3 levels are standard CDD for most common situations. For this, you're required to identify individuals by requesting identity information and verifying that information, seek information on the nature and purpose of the business relationship, and identify the beneficial owners of companies, trusts, and other arrangements. And for simplified CDD, that will be quite unusual. So you use that with specific customers or customer types that are considered to be low risk and that are specified in Section 18.2 of the Act. Enhanced CDD is for when there are factors creating a higher level of money laundering and terrorism financing risk or otherwise specified in the Act. You must use your own risk assessment and AML CFT program to assess the level of risk, and that will help you to determine which kind of CDD to conduct before establishing the business relationship or conducting an occasional transaction or activity. For enhanced due diligence, in addition to standard due diligence, you need to seek information on the source of funds or wealth involved in your client's activity and take reasonable steps to verify that information according to the level of risk involved. You need to conduct EDD, enhanced due diligence, in a variety of circumstances, including, for example, a client who is a trust or another vehicle for holding personal assets, a company with nominee shareholders. If a customer seeks your assistance to conduct a complex or unusually large transaction that has no apparent or visible purpose, economic or lawful purpose, or when you otherwise consider that the level of money laundering and terrorism financing risk involved means that enhanced CDD would be required. So when a red flag is raised, essentially. Guidance on enhanced due diligence is in preparation, and that will be released in late December. Okay, making a suspicious activity report. So the Act has been changed to expand from suspicious transaction reports, which you may be familiar with under the Financial Transactions Reporting Act, to suspicious activity reports, which cover a much broader range of the kinds of activities that lawyers might be involved in. Suspicious activities apply when a person conducts or seeks to conduct a transaction, requests or asks about a service that you provide, or when a reporting entity, so when a lawyer, provides or proposes to provide a service. You need to register on Go AML in order to report, so that's the database that the Financial Intelligence Unit used to record SARs, and training is available from the FIU. Reasonable grounds to suspect that the activity may be relevant to an offence. So that's what you have to have if you are making a suspicious activity report. You have to base it on reasonable grounds that the activity may be relevant to an offence. You don't have to be certain that an offence was committed. You don't have to launch a police investigation. You don't even have to know what offence it might have been. Reasonable grounds, for example, might be behaviour that raises a red flag. I'll talk a little bit about some red flags in a minute. A suspicious activity report must be filed as soon as practicable and no later than 3 working days after you become aware of facts that would objectively justify a suspicion, or by reasonable diligence would have become aware of them. The SAR is highly confidential. This is both to keep potential criminals unaware that a report has been made and also to protect the person making the report. If you've reported on your customer, you must not disclose this information to your customer or to any other person that is not entitled to receive the information. If, after making a report, you're unsure if you need to end your existing relationship with your customer, you may wish to review the conduct and client care rules for lawyers or consult the New Zealand Law Society or seek independent advice. Okay, some examples of red flags. So what kind of things about a customer might be suspicious? One is activity that is inconsistent with the client. So you know, for example, that your customer is a young student. So why are they investing large amounts of money offshore? This is where the CDD you do, finding out the nature and purpose of the business relationship, can really come in handy. So if you expect your business relationship to be about one thing and the person is conducting quite different kinds of business, then that may raise a red flag. If the customer is unusual for your business, here's an example from another sector, professional sector. The supervisor's visit found that a smaller regional reporting entity had all small local clients and one large offshore client who moved a lot of money through their account. All the other clients interact face-to-face. This unusual client never interacted face-to-face because they were offshore. The reporting entity didn't think it was suspicious because the client must have been rich. But why were they so different to the profile of the rest of their customers? Why were they choosing to do business with that particular firm? Another factor is when the customer avoids CDD or makes it really difficult to do CDD. Is it unusually hard to do your CDD? Maybe the customer is unusually private. Maybe they're shy. Or maybe it's suspicious. Why is it so hard to work out the beneficial owner of this particular customer? Why do you have to go through so many layers? Another one is lack of concern about loss. So we presume most of your customers want to make or retain money. So it's probably unusual if you have a customer who doesn't really seem concerned about losing a lot of money and makes transactions that result in losses without any particular worry about it. Red flags related to transactions, I'll comment on a few of these. Structured payments, classic money laundering technique, breaking down transactions to smaller payments, typically $10,000, which is regarded as some kind of threshold, although there is no threshold for suspicious activity reports. Is it usual for somebody, for example, to put $9,000 in one day, $8,000 the next, and then 2 more payments of $9,000 on the same following day? Why not just one payment of $35,000? It might be legitimate, it might not. It's time to ask some questions. The account appears to be used as a depository or conduit, so not for actually kind of keeping funds, but for moving funds. Money comes in and then goes straight back out somewhere else again. Ask yourself, is that usual for that type of business? Why are they doing that? Particularly if the money is coming in from one country and then out to another country. Unusually complex transactions. So there's a case study in an FIU quarterly typology report where a lawyer in the UAE was asked to facilitate the purchase of a hotel in Georgia. The buyer was a New Zealand company. The transaction was to be funded by complex intercompany loans, but it wasn't certain what any of the companies actually did or why they were loaning to each other. And the whole structure was too complicated for the lawyer to unpick. So it was all too out of the ordinary for the lawyer to be happy. So he made a suspicious transaction report, but add in that the company was owned by Iranian nationals with Caribbean passports. Okay, we can start to see that this is suspicious. Just a note about legal professional privilege. The AML CFT Act provides that a communication is not a privileged communication if there's a prima facie case that is for a dishonest purpose or to enable or aid the commission of offence, or if the information is kept in relation to the lawyer's trust account. It will be for lawyers to determine whether a prima facie case exists on the facts before them. This may involve considering whether there is some credible evidence that a communication is made for a dishonest purpose or to enable the commission of a crime. If there is that credible evidence, it is likely that professional privilege will not apply. The Act does not require any person to disclose any information that the person believes on reasonable grounds is a privileged communication. If it's possible for you to file an SAR without disclosing a privileged communication, you must do so. It's accepted that in some cases this will not be possible. AML CFT supervisors and the Commissioner of Police have a range of powers to require the provision of information and documentation for the purpose of ensuring compliance with the Act. These powers cannot be used to compel any person to disclose a privileged communication. Your AML CFT program should outline the procedure for determining and recording whether information is privileged. Generally, a person who makes an SAR will be immune from civil, criminal or disciplinary proceedings as a result. This will not be the case if information was disclosed in bad faith or if the information was disclosed by a lawyer despite the existence of reasonable grounds to believe the information was privileged. This highlights the importance of making a considered assessment in every case. If you need more support, you can get more detailed information and advice on professional privilege from the Law Society. Prescribed transaction reports. There are times when an entity is required to submit a prescribed transaction report, or PTR, to the Police Financial Intelligence Unit. If a client conducts a transaction in cash that is $10,000 or more, so a large cash transaction, or under certain circumstances, an international wire transfer or international funds transfer of $1,000 or more. PTRs help build the intelligence picture of financial activity by ensuring that the transaction is reported by the business which has access to key pieces of information. So, for example, who is the person behind the transaction? Transactions of physical cash are fairly straightforward. They need to be reported by the reporting entity or business that receives the cash. So if a lawyer does not receive cash and instead the customer deposits the cash in the bank, then the bank would submit the PTR. However, because wire transfers are often effected through chains of intermediaries, the obligation is less straightforward. Intermediaries are exempt. In the case of a wire transfer out of New Zealand, the PTR obligation falls on the ordering institution, the first entity to transact. That is, the first reporting entity instructed by a client to make an international funds transfer happen. An example is when a law firm that holds client funds in a trust account and is instructed by the client to transfer those funds overseas. In this case, it's the law firm that is the first entity to transact. Equally, if an entity is the first to receive funds from overseas and then makes the funds available to another person, they are considered the beneficiary institution and they are responsible for reporting. An example would be when a client has asked you to arrange receipt of funds from overseas into your trust account on their behalf. When considering your role in PTRs for international wire transfers, the existing guidance on wire transfers on the DIA website is a good starting point. Your annual report is submitted to your supervisor, to DIA, and it's submitted in electronic form. There's a prescribed form which will be set in regulations to come. If you want to know roughly what that form looks like, you can check out the consultation document which the Ministry of Justice set out a month or so ago, which is on the Ministry of Justice website. The annual report includes questions about the size and nature of your customer base, the type of service you offer to clients, numbers of transactions, and so on. We will use some of this information to get to know you and your business better. It will enable us to engage with you appropriately by ensuring we focus our attention where it's most needed. Through your responses to the annual report, we can see the general size and complexity of your business, as well as where you focus your appetite for risk. You will need to be prepared to provide that information in the annual report. This is likely to mean that you have to consider ways of collecting some information that you've not had to collect before. However, this kind of information is in line with what we would expect you to be recording and collecting anyway as part of your obligations under the AML legislation. To keep things as simple as we can, we've made the reporting period from 1 July to 30 June for every reporting entity. This means that you can collect the information during that period and then complete the annual report without having to think about calendar or financial years. Reporting starts in 2019 and it will cover the period 1 July 2018 to 30 June 2019. So you need to start collecting the relevant information from 1 July 2018. There's a 2-month window for submitting reports from 1 July through to 31 August. We've worked with the Ministry of Justice on the annual report form for the Phase 2 sectors, which will be provided in regulations by early next year. We will be providing guidance to help you in answering the questions, and this is scheduled for development by March 2018. Your audit. Every 2 years, lawyers and conveyancers are required to have an independent audit of their risk assessment and AML CFT program. An independent audit aims to ensure that documents remain up to date, that any deficiencies in program effectiveness are identified, and that any necessary changes can be made. The AML CFT Act requires you to appoint somebody who's independent and suitably qualified to conduct the audit. It's not appropriate for someone who's been involved in the establishment of the compliance program, such as completing the risk assessment and or writing the AML CFT program, to complete the audit. The auditor doesn't need to be a chartered accountant or qualified to undertake financial audits. To be suitably qualified, we expect that your auditor would have his transactions reported appropriately, records kept in accordance with the procedures set out in the program. It's very important that your program is implemented effectively and isn't just a sheaf of papers on a shelf somewhere. We cooperate with other supervisors, the Ministry of Justice and the police to ensure that we have a consistent and coordinated and that the AML CFT regime works well as a system and is supported by an overall strategic approach. We work with other jurisdictions and international bodies to share information and ensure that we're complying with international good practice standards. And we have a range of tools for intervening when we encounter non-compliance. These might be as simple as sitting down and having a chat to work out where you're going wrong and help you fix any problems. Or we can enter into more formal remediation arrangements that are still outside the space of legislative sanctions. For more serious non-compliance, we have enforceable undertakings and formal warnings. And finally, in very serious instances, we may end up in court seeking a civil remedy or an injunction or even taking a prosecution. We select which tool to apply according to the seriousness of the non-compliance we encounter and the attitude and mindset of the regulated business. Where a business genuinely wants to comply, we want to help it comply. This clicker is very non-responsive. There we go. But we are a responsive regulator with a non-responsive clicker. We aim to support our reporting entities to protect their business from being used by criminals and ensure a level playing field where all businesses are meeting AML CFT requirements. To do that, we need to understand your businesses and the challenges that you face so we can provide you with information that will actually help you. We're on a little bit of a learning curve in relation to the legal profession. There aren't very many lawyers in DIA, or at least people employed in the AML area, so we are learning about your business at the same time as you're learning about ours. We prioritise our activity to decide what should be done, and that priority is informed by risk. We risk assess the consequences and the likelihood of a reporting entity being misused for money laundering or terrorism financing. As well as money laundering and terrorism financing inherent risk, the attitude and compliance behaviour of the business is a factor in assessing risk. Because our approach is targeted and focuses mainly on higher risk businesses, you may not see us in the first year of operation or even the second year. However, we do typically select a number of lower risk businesses for review just to test our risk model, rule out the possibility of risk arising in businesses that seem benign, and help all businesses to comply. We've been working on improving how we assess risk and target our efforts. And in the coming months and years, we'll be working out how we can best do that with a regulated sector of 7,000 businesses instead of just 1,000. Okay, another timeline. This is a high-level timeline of what DIA will be doing to roll out Phase 2. First of all, we've been working with the Ministry of Justice and Police on developing regulations and guidance which will help the new sector understand how to implement the Act. If those regulations aren't out late this year, they will be out early next year. They're aiming for this year, but it being a political process, you can never be totally sure that the date that they're aiming at will actually materialise. However, we do intend to get the guidance out before Christmas, regardless of the timing for the regulations. The agencies involved in the implementation are working collaboratively with sectors to find out what will help them meet their obligations. We've worked through the development of these materials, the regulations and the guidance, with an advisory group of professionals from the regulated sectors who have generously put considerable amounts of time into helping us understand the needs of their business. Because we're moving so fast, we've needed to prioritise the development of guidance. We will address the most necessary issues first, those that are essential to help businesses establish their programs. The first set of guidance will be out by Christmas. This will include essential guidance, which I'll outline in a minute, in particular specific guidance tailored for lawyers and conveyancers. Further guidance will be published over the rollout period, starting with sector-specific guidance for accountants in about March, and for real estate agents around June. We'll also build on what has been done by amending and updating existing guidance over a similar timeframe. Just as we did for Phase 1, we plan to hold roadshows to help introduce you to your new obligations and provide further detail about the requirements. These will kick off in early 2018, either late February or March. And while planning is still underway, there's likely to be more than one round of roadshows. We're also looking into the future, and we're thinking about what kind of communication and education media are best suited to each sector. Where sectors have professional bodies, such as the Law Society, we intend to work closely with them to ensure that businesses get information in the way that's most helpful and accessible to them. Over time, we intend to test, develop and refine improved information and education services. So this is a very essential piece of guidance, the lawyers and conveyancers guidance, is just about the first cab off the ranks, and we're planning to publish that on the 15th of December this year, all going well. So these are the main headings that you can expect to see in the lawyers and conveyancers guidance. So it talks about your money laundering and terrorism financing risks. It gives an overview of how lawyers, in particular, are vulnerable to money laundering and terrorism financing. Whether the AML CFT Act applies to your business, and that includes what activities are captured, and a guide to help you establish whether you are conducting a captured activity. How legal professional privilege applies, your compliance requirements, your customer, an overview of the red flags. There'll be more detail on those in the sector risk assessment. A discussion of how to interact with your AML CFT supervisor and where to get support. The lawyers' and conveyancers guidance is designed to be as accessible as possible and allow you access to the whole range of guidance that you need. So it will contain links and references through to other guidance and useful sources for you. The sector risk assessment. The published sector risk assessment is guidance, and it applies to all Phase 2 entities. It assesses the inherent risk before AML CFT controls are applied. Now, as I said earlier, the easy access to and wide geographic spread of legal services, coupled with lawyers' gatekeeper role and their potential usefulness in many types of money laundering, means that your sector presents a medium-high inherent risk of money laundering and terrorism financing. This doesn't mean that the risk of money laundering and terrorism financing occurring within your own business is medium to high. You need to look at the extent to which your business is exposed to those specific vulnerabilities that are identified in the sector risk assessment for the legal sector, and then assess the risk for your business. As a companion document to the sector risk assessment, we're publishing a document called Prompts and Notes, which is also out in December. This will provide direction and basic information on supervisory expectations to help guide your thinking in developing your AML CFT risk assessment and program. It doesn't provide a template or a step-by-step guide. This is because each business has unique circumstances that determine their exposure to money laundering and terrorism financing risks, which need to be understood and factored into their unique AML CFT program. And businesses need to apply their own judgment when setting up their AML CFT program, and as I think I've emphasised, it can't be a cookie-cutter approach. Other guidance, which is out in December, we've got updates of the guidance on ordinary course of business, so how to determine whether an activity is in part of your ordinary business. Guidance on how to set up a designated business group, and enhanced due diligence guidance, which is new. So enhanced due diligence is a complex issue, and we are creating some guidance to assist you through that area, which can be a little bit of a minefield. And there's more to come, so the existing guidance that's on our website will be progressively updated over the next 12 months or so. One thing that you'll notice is that the lawyers and conveyancers guidance is in a format and actually has a kind of flavour that's a little bit different from the existing guidance on our website. That's the kind of thing that you can expect to increasingly appear as we update and renew our guidance. It's kind of the new look guidance. Right, we're just about at the wrap up here. I thought I'd talk a little bit about how you can reduce your compliance costs. If you do have AML CFT responsibilities, you don't necessarily need to do it all by yourself. You may be able to share some of the costs with related businesses. For example, you could form a designated business group, a DBG. You could rely on another business for customer due diligence, or you could outsource customer due diligence to a third party. The formation of DBG enables similar reporting entities to reduce compliance costs by entering into an agreement to share an AML CFT program and risk assessment. The amendment to the AML CFT Act has broadened the ways members of a DBG can be related to include a related law firm or a subsidiary. A DBG does not exempt a member from conducting transactional obligations such as customer due diligence or from submitting suspicious activity reports. When you're considering whether to form a DBG or not, you may find it helpful to contact us, DIA, to work through it with you. If you're not sure whether or not your proposed DBG meets the criteria in the definition in Section 5.1 of the Act, you're welcome to contact us to discuss that. We'd prefer if reporting entities test their proposals with us rather than assume that they don't apply. If you're interested in applying to form a DBG, we recommend you familiarise yourself with two available guidelines to assist reporting entities to create DBGs, one on scope and one on formation, before you submit an application. Reliance provisions enable businesses to reduce their compliance costs through relying on another reporting entity to conduct customer due diligence. Consent must be obtained from the reporting entity conducting the CDD prior to relying on that reporting entity. A reporting entity is not responsible for ensuring that the CDD has been conducted correctly, provided they are acting in good faith and have reasonable cause to believe that CDD has been conducted to the standard expected. Finally, just a few tips. Get started now, I've already said that. Don't wait for the regulations and guidance. So there's plenty of existing material that you can be using to start thinking about your risks and setting up your risk assessment and your AML CFT program. And don't overinvest. So there are many opportunities that consultancies and so forth are taking to offer you products and software and systems that may help you with your AML CFT program. Now, I'm not saying there's anything wrong with those products or systems, but before you invest in something very expensive, just look at your risks and make sure that what you're doing is worthwhile, is worth the investment. What we expect of you: be willing to do the right thing. Showing up here is a great start, and I'm very impressed that so many people have shown up for this webcast. Own and understand your AML CFT program. A consultant may help you create a program that ticks all the boxes, but it's not worth the paper it's written on if it's not implemented and understood by the people in your business who have to use it. And that's what we will be looking for when we review your program. Ownership isn't the sole responsibility of the compliance officer. It's the responsibility of senior management, and it needs to percolate throughout the entire business. And finally, ask us for help if you're not sure about anything. I've put up some contact details there. We have an address that's specifically for Phase 2 businesses to contact us, just so that we avoid swamping our very diligent and hard-working BAU team with lots and lots of questions. So please use the AML Phase 2 at DIA address if you've got questions that you want to send to us. Our webpage, so it's the DIA webpage, so that's at the moment got a lot of existing guidance on it. It will also have the lawyers and conveyancers guidance and the risk assessment guidance and the other guidance that we're intending to publish by December. And the Ministry of Justice webpage has sort of general information on the Act and the policy process that led through to the Act, and kind of more generic information covering the Act as a whole. And that's me. So now it's time for some questions, if anyone's got any. Okay, so we have question 1, and our handy question asker over there in the corner is going to ask the question.
Hi, Kate. I'd be interested to understand how the legislation will apply to in-house lawyers as opposed to law firms.
Okay, so the Act is activities-based. So if you're an in-house lawyer and you work for a firm that doesn't carry out any of those activities that are named in the Act, then you're probably not covered by the Act. The guidance, the Lawyers and Conveyancers guidance, provides a flowchart that will help you determine if you're captured. And in a law firm, I might add, that when you've got a lot of lawyers sort of grouped together in a law firm, it's the firm that is responsible for compliance, not each individual lawyer, for developing and maintaining the AML CFT program. Each lawyer, of course, needs to comply with the AML CFT program and carry out those duties as required, which might include, for example, identifying suspicious activities and alerting your compliance officer to those suspicious activities. Right, I now have question 4.
Are we going to be kept updated on jurisdictions that are deemed to have weak AML controls, or are we expected to make our own judgment call?
Okay, so there's existing guidance on our website, the Countries Assessment Guideline. You can also use various international sources. One good place is the Transparency International Corruption Perception Index, and there's Basel AML ratings that are done by the Basel banking regulators. By using these and potentially other reliable sources, we expect you to make a judgment call and accept a level of risk that you're comfortable with. There isn't any requirement to absolutely embargo countries under the AML CFT Act, and in fact individuals even from very highly corrupt countries, you may make a judgment call that the individual that you're dealing with is trustworthy. But that's up to you. Also, you can look at mutual evaluation reports on countries by the Financial Action Task Force, UNODC, I can't even read that, reports on organised crime, and there are also reliable, trusted media sources that can assist. Okay, next question, please.
Hello, Kate. To what extent do I need to verify a new individual client's employment and how they got their cash if purchasing a house? Do I view their employment contract or look at more than 3 months of bank statements?
Okay, things that you need to consider in that case. Who is your client? What do you know about them already? Are they high, medium or low risk? Are there any other potential beneficiaries? Who are the other beneficial owners, if any? Is the level of cash unusual? Are you entering a business relationship? First, you need to determine the range of information you require based on your assessment of risk and the legal requirements. And then you need to determine how best to verify that information. The guidance will help you, but you also need to make your own professional judgment. And you need to keep a record of that decision. Next question.
Whilst I appreciate that rules and regulations are yet to be published for lawyers, one big issue that will arise is the cost of compliance. How are such costs to be met by clients or by the law firm?
Okay, so there are costs of compliance, I acknowledge that. It's something that law firms do have to wear. But you can actually usually tailor your AML CFT program to suit those costs. So if you're a small firm, your AML CFT program is likely to be a lot less elaborate than if you're a large firm. And that kind of suits probably the simpler nature of your business. As your supervisor, we aim to provide education and support as appropriate, and that can help you reduce your costs. And your professional body will also help. You can, as I've talked about earlier, join up with other related law firms to form a DBG if that's appropriate, and you can also make an arrangement with another reporting entity to outsource customer due diligence, which may help you also reduce your costs and reduce double handling. It will be your choice if you seek further help from consultants. That they may be helpful in helping you set out your AML CFT program, but there is an upfront cost. The risk-based approach also helps because it helps you assign resources as appropriate. So you won't be carrying out the same level of due diligence on every customer. So you'll be able to actually put most of your resources into those high-risk areas. Right, next,
Yes.
guys.
It seems to me that we are being compelled to dob clients in if we suspect something suspicious. And if I am correct in that regard, that throws a fundamental premise of our profession into disarray.
Okay, so as I kind of noted before, the AML CFT regime is designed to be compatible with your obligations to protect legal professional privilege. Your suspicions may or may not be founded. This is for government authority to determine, not you. You can still act for a client you're suspicious of if you're comfortable with that and if you're able to complete CDD and other requirements, legal or professional. However, if you're not comfortable with it, then we highly advise that you do cease that relationship.
Am I right that this only applies to lawyers who have a trust account? So if it doesn't apply to barristers and those who practice without a trust account?
It depends on the activity you undertake. It's certainly not just about the trust account. So if, for example, you're setting up firms, you're dealing with trusts, you're dealing with people who if you're dealing with real estate transactions, for example, whether or not you're doing that through your trust account, or if you're giving any kind of advice on those activities that are captured by the Act, then you'll be covered. So it's not just about trust accounts. Next one.
Given the seriousness and complexity of this compliance, will DIA provide any compliance officers in the future to assist businesses to meet their obligations?
Okay, so we don't provide compliance officers. What we do provide is a service to help you meet your obligations. So we can certainly answer your questions. Part of our responsibility as a modern and responsive regulator is helping you meet those obligations. So to do that, we provide guidance, we provide newsletters, we conduct those desktop reviews, and we give you feedback on the extent to which you are or are not complying with the Act. We have outreach functions like this webinar and the roadshow, and there will certainly be further opportunities for that kind of thing as we move on. DIA has more resources now to do this, so we got additional funding as part of this change in the legislation to enable us to to really enhance our education and information function. That will take time to set up, and we'll be working very closely with the Law Society and with individual firms to ensure that what we do is targeted in a way that really helps you. Next one.
What are lawyers expected to do by way of CDD in respect of existing clients and files? Do we undertake a review applying CDD risk assessments to all existing clients?
Okay, so existing customer is defined in the Act as a person who was in a business relationship with the reporting entity immediately before the Act began applying to the reporting entity. So you have to conduct CDD on existing customers if there's a material change in the nature or purpose of the business relationship with that customer, and you have insufficient information about that customer. When you're considering what information would be sufficient, you need to assess the level of risk involved and whether you hold the necessary identity information that is verified at the appropriate level. So the answer is basically yes, you do, particularly, and a good trigger for when to do that is when there's a change in the business that they're doing with you. You also need to conduct ongoing CDD, which basically means checking with your entire customer base to make sure that you've actually got the correct information and that it's up to date and that you're still aware of what the nature of the business is they're doing with you and that hasn't changed substantially. Are we out of questions?
Plenty more.
There are more. Oh, but wait, there's more. Okay, next one, roadshows.
Will the roadshows come to smaller provincial towns?
Yes, to an extent. I think we're going down to levels such as smaller cities, so Nelson, New Plymouth, Tauranga, Whanganui, Invercargill. So they will be in smaller centres and not just the really big main centres. The major cities will actually host several roadshows, so we'll have 3 or 4 in Auckland, for example. So we are doing this in partnership with the Financial Intelligence Unit from the police, and we're keen to visit as many provincial towns as possible so that we get really kind of broad coverage. We did this in phase 1, and it was really important and really valuable for the newly regulated entities to meet us face to face and for us to be able to answer their questions in that environment and to respond sort of more specifically to them. So what the roadshows really are a kind of a travelling version of the guidance. So what we're doing is rolling out the guidance in a face-to-face interactive environment. And we're currently working on the schedule for those. So watch this space.
Next question. Will you lose your potential client if you outsource the checking to another bigger player?
The rules apply to every reporting entity. So regardless of who does the checking, the same level of checking is required. If they are not checking, then they're actually not complying. So if you lose your client, then exactly the same rules will apply in another place. And that's actually what you can advise your client. It's not going to, they're still going to have to provide that identity information no matter which lawyer they go to.
Okay.
Next
What
one.
is included in managing client funds? Does it extend to receiving funds on account of legal fees and using those funds to pay fees once invoiced?
Okay, so the DIA's view is that managing payments to or from your customers' accounts is captured. And with the exception of payments for professional fees, any instance where you receive or hold clients' funds and deal with those funds in accordance with client instructions will also be captured. I think that's clearly intended to be captured in our view, because it's a key source of the kind of transactions that may be involved in money laundering.
How is DIA going to investigate every report of a transaction of $1,000?
Okay, so that indicates that there's a misunderstanding there. So DIA doesn't receive those reports of transactions. So the significant cash transactions of $10,000 and over, and the international funds transfers of $1,000 or over are reported to the Police Financial Intelligence Unit. What the Police Financial Intelligence Unit does with that information is they collate it and they use it to paint the overall picture of movements of cash and money in New Zealand. They look for unusual patterns. They look for potential areas where there might be laundering taking place. They then use that information and that intelligence to help inform police in their investigations of possible crime. So it's kind of a third-hand activity. So all that information goes into a big pool of financial intel. Exactly the same thing happens in Australia with AUSTRAC, who run the Australian Financial Transactions Intelligence Service. So they've had this system in place for a number of years where reporting entities have to report significant cash transactions and significant overseas transactions to the FIU, which then use that information to help inform police investigations. The FIU also handles suspicious activity reports, and that goes into a similar kind of pool. So your suspicious activity report is not necessarily going to be used immediately for a police investigation. It will go into the FIU. They may choose to alert law enforcement to this transaction, or they may keep it for safekeeping and forward it when it's necessary, when there's an actual investigation that seems to be related to that transaction taking place. So they produce intelligence products, so reports on the kind of transactional patterns that are emerging from that information, and they disseminate those to other agencies, so police, customs, IRD, and also to international police for international investigations.
It would be useful if DIA or the Society came up with some suggestive modifications to our terms of engagement that flags our expectation to make inquiries of clients to comply. Have you got much to say about that?
Yeah, okay. Yes, you're right. So we've been in close consultation with the Law Society about this. We understand that they are looking at a range of communications for clients, so that will assist lawyers in helping their clients understand why these new requirements are in place, why they're being asked to provide additional forms of information about themselves, and how that actually, what the purpose of all that stuff is. So that's in the pipeline.
Do we have to forewarn our clients?
Okay. It makes sense to communicate with your clients about the impact of those obligations. Phase 1 entities have been doing this for some years, so it's now become basically BAU if you're dealing with a bank that you have to provide due diligence information. So customers do get used to it. So it's good to establish expectations early. If you're talking about forewarning in the sense of I'm going to make a suspicious activity report about you, then no, definitely not. That's illegal.
How will DIA know if it's working if the lawyer has, rightly or wrongly, decided it's privileged and not reported?
It's up to a lawyer to decide, and they should record this. DIA will never ask for privileged info. A district court judge may be called in to make a decision if legal professional privilege applies, or I can't read that answer, sorry. Are there any more questions?
There are. One on the fly here, is it? What are lawyers expected to do in terms of CDD when we receive instructions from an overseas firm and our client is that firm?
That's a very technical question that I think may be answered in the guidance.
Okay. Sorry, we're just sorting through some more questions here.
Some of these questions are a little bit beyond my pay scale, I think. Some questions, particularly more technical questions about customer due diligence, are stuff that our technical experts may be able to answer more easily than I will. So we'll definitely keep that one aside and provide a written answer on it for you.
If my initial due diligence raises red flags, without further work for the client, can I back out of the engagement? Am I obliged to report to DIA?
You can always back out of any engagement. If red flags are raised, we do recommend that you report to the Financial Intelligence Unit. I need to emphasise again that there's a difference between the Department of Internal Affairs, which is basically your regulator and your compliance supervisor, and the Police Financial Intelligence Unit, which is where you report your suspicious activity reports. But yes, if there's a red flag and if it comes up in your in your AML CFT program as an activity that would raise a red flag, then you do need to report that, and you are absolutely entitled to back out of that relationship if you wish.
How far do the obligations extend to identify beneficial owners of, say, a family trust, when there could be many, many possible beneficiaries?
Okay.
Many of whom will not know they're beneficiaries.
Yeah, so when you've got a trust with more than 10 beneficiaries, or a trust that is what's called a discretionary trust, where the beneficiaries are not identified, then there are special cases in point. So with more than 10 beneficiaries, I think there's a limited number of beneficiaries that you need to identify. In the case of a discretionary trust, you just need to take a record of what the actual purpose of that trust fund is.
Is there nothing in writing about enhanced due diligence?
There will be something in writing about enhanced due diligence by the end of the year. But there are some guidelines on due diligence existing right now. They've got a financial sector flavour. The enhanced due diligence guidance that's coming out by the end of the year just drills much more deeply into what you do about enhanced due diligence and how you deal with the particular kinds of circumstances that you're likely to meet in that kind of high risk situation.
How can we justify to clients that we want to know where their business gets its funds from?
Well, again, I think this is a matter of clearly communicating what the purpose of those questions are. It actually helps if you've got somebody who's fronting up with your client on onboarding who can kind of establish a rapport with the customer. With your client, so that they kind of actually kind of can get them in a situation where they feel okay. So somebody who doesn't feel awkward about asking those kind of questions is the best person not to make your client feel awkward or kind of imposed upon by providing those answers. But again, I think we'll be working with the Law Society to ensure that there's appropriate information available for you to provide to clients before you onboard them.
Wouldn't it be more appropriate for an associate or partner to be a compliance officer rather than an employee of the company, given the personal liability involved?
Yeah, that is a business decision. I think that an associate or a partner could be a compliance officer. I'm pretty sure that would be allowable under the Act, but it's up to your business.
Can DIA carry out the audits free for sole practitioners?
Say that again, sorry.
Can DIA carry out the audits free for sole practitioners?
No, DIA doesn't do the audits. What DIA does is it check compliance. That is, in fact, a free service. Audits are services that you have to get at your own expense. So we do not audit, we do not carry out those biannual audits.
If we know the customer has a New Zealand bank account and the bank has done due diligence on that customer already, why am I having to do due diligence, perhaps enhanced due diligence, all over again?
Okay, so there's a couple of things in the Act that can apply to that. One is that you can, if the bank consents to it, arrange for that due diligence to apply as your due diligence. So that's the reliance provisions that I talked about before. But the bank actually has to agree to do that. So that's something that banks may or may not agree to do for you. Secondly is, as I said earlier, it's really important for our purposes that lawyers understand their clients and so that they can make meaningful reports if there is a suspicious activity or transaction. So it's very important that you have that information as well as the bank having it. I think we're going to wrap up now. Is that correct? Yes, I think we're out of questions. Thank you very much, everybody.
Well, thank you, Kate, very, very much for your presentation and questions. And don't forget that the written answers to questions that have been mentioned will be emailed. You know, there have been quite a few questions and it will take time to collate all the answers and so on, but it will be emailed to you in due course. And thank you everyone for attending, both at the Law Society and online, part of our largest online event as yet. And so congratulations on being part of that. Now, you'll be sent a certificate of attendance for your own CPD records this afternoon, along with a link to an evaluation, which we do appreciate when you take a few moments to fill that in. You might also be interested in attending a couple of other AML CFT webinars. There are two coming up, presented by Henry Brandt-Geeson and Neil Russ. The first one on 22nd of February is on compliance programs, and the second on the 28th of March is on due diligence. You can attend both of those for one special price, and you can find out about them on our website. So it only remains for me to thank Kate again and the Department of Internal Affairs for today's presentation. Thank you.